Yes.
Now we're on 21.
It was number 20.
Oh, it's Linder's 21 now.
Linder. Yes. Assemblyman, welcome. We have two items of yours. Our 21 and 32, which is your 2088 and 2510. Shall we take them in numeric order?
Sure thing.
Okay, so that would be 2088.
Hit and run.
Welcome.
Well, thank you, Chair and members. Hit and runs have risen to epidemic proportions in California, and unfortunately, there's no sign of them slowing down. The latest numbers to come from CHP show an increase of 73,000 hit and runs in 2014 to 79,000 in 2015. There was one awful case just recently occurred right outside of my district. A first grader, little girl, was walking home from school when a red Chevy pickup truck crashed into her. The driver left this little girl lying in the street with several serious injuries. She spent her 7th birthday in a hospital bed, awaiting a future of reconstructive surgeries and extensive rehabilitation. The driver was arrested a few days later. His future is yet to be decided by a judge. Now, believe it or not, under California's current penalty structure, he could possibly settle in court and get off with a couple $100 fine. And that's it. Hit and runs occur in all of our districts, leaving families torn apart with nothing to turn to but unjust laws. The bill applies specifically to hit and run drivers who injure an individual, but either enter into a plea bargain agreement where the sentence is reduced to a hit and run only with property damage. Under current law, the driver can settle in court with only having to pay a couple $100 fine. AB 2088 corrects this injustice by requiring hit and run drivers who were involved in a collision where there was injury involved to either perform community service or adhere to the terms of a license suspension. The idea behind this bill has been vetted for over a year and a half, and I wish that I could claim full credit, but the language I present to you today has truly been a bipartisan effort. While some concerns still may exist over limiting court's discretion, I want to stress that the court now has 3 penalty options ranging from a couple hours of community service to 6 months worth of license suspension. So that, yes, the court already has the discretion to suspend an offender's license or require community service in these case scenarios, but we will need this bill to guarantee that a hit and run drivers are adequately held accountable to the suffering that they cause. So with me is Damian Kevitt, who will share his personal story as a victim of hit and run and how his experience inspired him to start up a nonprofit named Streets Are For Everyone, or SAFE for short.
Committee members, thank you for taking a moment to listen to me. In February 2013,
Could you introduce yourself again for us?
my name is Damian Kevitt. I am Executive Director and founder of Streets Are For Everyone, an advocacy group focusing on street safety for pedestrians, cyclists, and all road users. My story starts in February 2013 when I was cycling in Griffith Park with my wife on a Sunday morning. I collided with a car in what would have been a minor collision had he stopped. Because he didn't stop, I ended up pinned underneath the car, dragged nearly a quarter mile from the streets of Griffith Park onto and down the 5 freeway. My right foot was basically severed, about 15 pounds of flesh was ripped off, and 20 bones were broken. I was luckily conscious enough that I could get free and was left in traffic lanes on the 5 freeway. For 4 months, I was in the hospital, and during that time, I learned of the epidemic of hit and runs across California, and more importantly, the fact that LA is the hit and run capital of the US. LA County alone, we're looking at 7,500 people every year sent to the hospital or killed just in LA County. It was at that point that I basically took the path of starting Streets Are For Everyone and deciding to do something about this, and really championing the cause of hit and runs. Each of the committee members here has their social issues that you champion. And I guarantee you, if I were to go through the list of those that you care about, one or several of them are directly related to or impacted by hit and run crimes. Whether it's specifically on the issues of justice, where I regularly run into victims of hit and run crimes that have their perpetrators walk out of the courtroom and with little more than a fine and a slap on the wrist, when they're left with permanent injuries or loved ones that are killed, Specifically, a recent example is a Pasadena lady named Gianna who contacted us, lost her mother due to a distracted driver, who then ran and left her mother on the side of the road to die. He walked out of the courtroom with a $250 fine and drove away. I don't really consider that justice. Kids, education, childhood obesity, all of those points are affected by exercise and getting outdoors. There's a whole program from the federal government called Safe Routes to School program. That program is to make the routes to school safe from crime and traffic collisions and hit and runs. Millions of dollars are pumped into that every single year and have direct effect upon that. Or you could deal with the elderly, and some of you may have read a series of articles written by the LA Times on the subject of hit and runs and who they affect, the demographics. What came out of that? Well, children and the elderly are disproportionately affected by hit and run crimes. Enough said. I think I've made my point on the subject. But I close with this. By the grace of God, I was given a second chance. I chose to take that chance to champion the subject of hit and runs and traffic safety. It's been an epic battle that I've been working on for years now. So I invite you to actually take part in that struggle that I'm working on and do an aye vote for this particular bill. It's a simple and sensible bill. Thank you.
Thank you, Mr. Kevitt, for your very articulate presentation. I'm so glad to see you thriving
Yes.
after such an ordeal. Good gosh.
Yeah, it was a bad day.
Thank you. Ms. Gepke.
Thank you, Mr. Chair. Members, Dawn Kepke on behalf of Crime Victims United of California, and very strong support. We think this is a modest bill that is critically important to help address the perverse incentive of fleeing the scene in these situations, and really just urge your aye vote on something that we think will help address that issue. Thank you.
Thank you.
Thank you, Mr. Chair and members. Moira Top on behalf of the Orange County Transportation Authority. As we have expanded our active transportation network, we grow increasingly concerned about increased incidences of hit-and-run accidents. We think this is a common-sense bill, and we appreciate an aye vote today. Thank you.
Thank you. Others who would like to speak in support of Assemblyman Linder's 2088?
Mr. Chairman, members, Randy Perry with Porrick in support.
Thank you, Mr. Perry. Anyone else? Is there any opposition?
Guess I'll go. Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, Statewide Association of Criminal Defense Attorneys. We do have concerns on the bill, primarily focused on a procedural aspect, which is also constitutional in nature. The bill essentially not only takes away some discretion of the judge to impose an additional penalty, but it also is structured in a way which we believe violates the number of U.S. Supreme Court decisions, including Cunningham and Apprendi and a few others. And that is because whenever there is an additional penalty on top of whatever the base term is, and it is based on a fact or a fact in aggravation, then the Supreme Court has indicated that that fact must first be presented to a jury, and the jury must determine that that fact is indeed true beyond reasonable doubt. And at that juncture, the judge can then take that fact into consideration when imposing a sentence. Our reading of this bill is that this additional fact is stated on the record, I believe, as somebody is injured, but it has never been presented to a jury, so it presents kind of a difficult question. It's almost squarely within the Supreme Court decisions, because, again, if the baseline offense requires a certain sentence, okay, but if you're going beyond that and adding anything new, you must present that to a jury, and we've talked about that extensively in this committee. I know 2 of the committee members have talked about Cunningham. So regardless of the merit of the policy discussion, that procedural constitutional issue we think needs to be overcome, and we don't believe it is overcome with the way that the bill is currently drafted. We understand it's in plea bargaining, so it creates kind of a gray area, as opposed to someone found guilty. And I think that's why I say it's not squarely, but it is definitely in the same, kind of rubric of whether or not it has to be presented to a jury first. And I think we need to explore that a little bit and rectify any constitutional defects on that. So that's our primary concern. I'll defer to the others for their other issues.
Mr. Hernandez, I think I heard you say that the statement of fact that we're talking about specific to this bill is that someone was injured.
That's my understanding of the bill. That's correct.
So it would seem that that could be addressed, different from the broader issues of Cunningham, which are in a bill that I think you're sponsoring, that I'm authoring, which is outside the gray area that you've just defined this particular issue to be in. So is there a way that we could enhance the statement of fact? I mean, if someone's either injured or not, a medical document, something could, you don't need a jury to determine someone's been injured. Though
Sure.
Relative to this Sixth Amendment, yes.
Right.
But as a statement of fact, it's not that difficult to substantiate.
Right. I think procedurally, and again, I'm speaking just kind of off the top, so.
As am I.
I have to be careful because I'm on the record. But I would imagine that if there's some sort of stipulation from the defense or the defendant to certain facts, that may get us outside of that. If there's not a stipulation, then I think we are in the gray area of whether or not is allowed or not, because again, the bill specifically is going beyond the existing penalties and the maximum penalty, and that's exactly what the Supreme Court was trying to address. So I think that may be the only way that I can think of off the top of my head, but certainly willing to have discussions about that. But I would imagine a stipulation from the defense, but absent that, or if in fact the defense say, well, willing to plea, but we don't believe that there was an injury to substantiate the additional penalty, then we really get into the quagmire where we have somebody willing to plea, which is a good court efficiency, but they want to dispute that one particular fact, and they really won't have an opportunity to present witnesses, or certainly not in front of a jury. So.
Thank you.
Thank you.
Others in opposition?
Billy Foster on behalf of the California Public Defenders Association in opposition to this measure. We understand the epidemic of hit and run, but we do not believe this bill will do anything to further the cause of justice in that area. DAs are not in the habit of casually reducing injury hit and run charges to non-injury hit and run charges. They do it only where there was a real question about whether an injury actually occurred and where there were serious proof problems. Furthermore, the most serious consequence of hit and run charges for the clients that we represent is the loss of their driver's license, because it is essential to their jobs and the proper functioning of their families. To remove the prime defense advantage of reducing the charge to a 2002 is to force more defendants to demand a trial, which will cause more expense to the court system and is likely to result in more acquittals, because the DA wouldn't offer the reduction if the case didn't have problems in the first place. The inevitable result of this bill, if passed, would be that the DAs would have to be deliberately unclear when stating whether an injury was involved in an accident, or more likely, the parties would agree to a plea bargain to another lesser offense other than a 2002, which may not carry the 2 points on the driver's license and the suspension of the license. Plea bargaining is a prosecution function. Courts are prohibited from unilaterally engaging in that process, and they should likewise not second-guess the decisions of prosecutors. The judges already have the discretion to order community service, and we don't think that this bill is necessary. Thank you.
Thank you, Mr. Ostagai.
And just very quickly, Micah Doctoroff on behalf of the ACLU of California, also in opposition. We believe that this bill unnecessarily and improperly strips courts of their discretion. Courts can already restrict or suspend drivers' privileges for up to 6 months, even if there's no injury. Courts can also impose community service when appropriate. So we do not believe this bill is necessary, and for these reasons, we are also in opposition.
Thank you, Ms. Doctoroff. Assemblyman, would you care to respond to some of the concerns?
Certainly. First off, I want to stress, as the gentleman from the was it the Public Defenders Association? I firmly believe in our due process system. So if it does result in more cases going to trial, I think that's probably a good thing, because I do think that we have the best due process system in the world, and I think that could be very the fairest form of determining whether or not these people are indeed guilty. In regards to the plea bargaining, this bill was taken word for word from the wet reckless statute. And that being said, if this bill is considered unconstitutional, then that should be the case for wet reckless as well. As with wet reckless plea bargains, this bill is designed to ensure that if the charges are reduced, that there will still be a consequence. In the case, suppose one of these happens, we've added language to the bill so that the defendant is notified of the consequences of accepting one of these pleas, by accepting the guilty plea. So we have taken that into consideration. So hopefully that.
And with regard to the comments regarding Sixth Amendment concerns, that it should be a jury that determines the fact that someone has been injured as opposed to the DA making the statement of fact.
Again, in this case, they're going to be notified ahead of time of the consequences of accepting, the decision ahead of them is going to be, we either plea bargain down to this lesser crime that might have a lesser sentence, or they go to the court and face the facts that, that where they will be presented, all the evidence will be presented against them in the court. So they will be aware of that is going to be a part of their decision into how to plea.
So that's a slightly different issue than the Cunningham decision, which had determined about 10 years ago that our triad sentencing structure was unconstitutional because it allowed for an upper term determined by a judge as opposed to a jury making a determination of extenuating circumstances as fact. So this issue of fact, as Mr. Hernandez pointed out, more of a gray area than a stark concern with the Cunningham decision. So that may be something I want to pursue with you further.
Sure. And I'll gladly work with
as the bill moves forward. And also working with Mr. Hernandez, who I think will have further opinions on this. Questions from the committee? Senator Stone.
Thank you again, Mr. Chairman. I really appreciate the testimony of Damien. That was a horrific incident. Godspeed to you, sir, and appreciate your making this your lifetime focus now to ensure that those people that hit and run and cause morbidity and mortality are held accountable. This is a very modest attempt at doing that through a plea bargain that allows for 3 other modalities to be imposed. So, Assemblyman, I appreciate that you've taken this task on. It seems like there's a little bit more work that might need to be done, but I think it's important that we get it out of committee today so that you have that opportunity to continue to work with the opponents on the issue, and hopefully this bill will become a law so that there'll be less Damiens out there that have to worry about holding those accountable that hit and run 7,500 cases. It's terrible. It's happened, as you know, in our district, even locally in Murrieta, Temecula area, we've had some hit and runs. So I think there's something that's pervasive throughout the state of California that needed addressing, and I appreciate that you've done that. And with that, I'll move the bill.
Senator Monning. Thank you, Senator Stone.
Thank you, Mr. Chair. I just had a couple of questions. I appreciate you bringing this forward. I actually have a family member who was a victim of a hit and run, so I'm familiar with the seriousness of it. But I do have some of the concerns raised by the opposition in terms of, as I understand it, this mandated sentence options, 6 months driver's license suspension or community service. Is that the ceiling that can be imposed? Can a judge impose a higher sentence?
My understanding, since this is in a plea bargain scenario, this is what could be offered, and that the judge does have discretion to adjust it in the process.
Yeah, I do understand this is really establishing minimums in a plea bargain, that if a guilty plea without a trial is part of that plea bargain, the way this reads, it's establishing kind of a floor, but I do wonder whether a plea bargain in an egregious case could include a higher sentencing as a function of that plea bargain, or if the defendant's going to say, I'm giving you my guilty plea, you can't
Go any further,
than this. So
If that is the case, then I will amend the bill to make sure that that is clear, because that certainly isn't the intent to say, oh yeah, I'm going to get a great deal on this. We want to be as we want to discourage people from doing the hit and runs as much as possible.
So, and some of the questions asked by the chair, I also do share some of those concerns. I may stay off today, see what it looks like when it gets to the floor, give us a chance to answer that question. Thank you.
All right, appreciate it.
Thank you, Senator Monning. We do have a motion. Assemblyman, I will support the bill today, but with some reservations. And I think that this Sixth Amendment concern, as Mr. Hernandez raised, is not that difficult to resolve, in that if we could have acknowledgement by the defendant, for example, that an injury had occurred, then we wouldn't be in conflict with the Cunningham decision or in need of a jury determination of that fact. So I hope you'll be open to that. I don't want to impose anything upon you here today. Give you time to think about it, have some further discussions with both proponents and opposition, and see if that couldn't be resolved. I think it could make it a better bill, and then you wouldn't have to have concerns that it could be challenged constitutionally should it get signed into law.
Well, in that case, I look forward to working with your office.
Good. Okay, so we do have a motion, and we will call the roll. Would you like to close? Thank you.
Thank you. I just want to remind the members of this committee that California is home to the hit-and-run capital of the nation. Last year alone, only over 200 people died and 21,000 were injured in hit-and-run collisions. I'd like to make one correction from my good colleague from Temecula. He said 7,500. No, the statistic was 79,000 in 2015. So this is quite a significant number. We have to fix this. This bill puts us on the right track by ensuring that hit-and-run drivers are held accountable for the suffering that they cause. Given the frequency that they happen in our state, this strikes just the right balance between granting judicial discretion and accomplishing deterrence. So I respectfully ask for the aye vote.
Thank you, Assemblyman. San Francisco being as dense of an environment as it is, just 49 square miles, dense and dangerous, we have a municipal goal of Vision Zero to eliminate all pedestrian and bicycle accidents and certainly deaths in the near term. And though I see Los Angeles Walks is one of your supporters, I'm sure Walk San Francisco would also be in that category if it's not officially received or not yet. So another reason why I'll be supporting the bill, but again, look forward to addressing that one issue with you. Sure. Call the roll, please.
Hancock. Anderson. Glazer. Aye. Glazer, aye. Leno.
Aye.
Leno, aye. Liu. Liu, aye. Monning. Stone. Stone, aye.
Aye.
We will place that on call.
Thank you.
And I know you have a second bill, which is item 32, AB 2510.
Thank you. Here's your update.
Okay.
Well, thank you again, Mr. Chair. Members, here presenting Assembly Bill 2510, a bill that would provide uniformity to the concealed carry license program of the state of California. This legislation, which passed out of the Assembly without any no votes, will authorize local law enforcement agencies to issue CCW ID cards approved by the California Department of Justice. Currently, the permits are issued by the Department of Justice and are large, cumbersome paper documents not easily carried on one's person. They can be ruined by water or accidental tears, which forces licensees to continue having to request new permits. This is a burden on both the CCW holder and the issuing agencies. In In an attempt to ease this burden, some sheriff's offices have begun providing county identification cards that are similar to driver's licenses. Unfortunately, these IDs cannot be used in lieu of the paper permits issued by the Department of Justice. AB 2510 will allow local law enforcement to continue providing ID cards that are better suited to be carried and can be presented as proof of license in the state. The cards will contain the exact same information as the current DOJ permits. Additionally, in order to achieve uniformity and to provide adequate training for the officers, the DOJ will retain examples of each of the identification cards issued by the counties, as well as the names of the counties providing them. We're currently working together with any opposition to find a way to mitigate and appease any concerns, and I will continue to work forward with them as this bill moves forward. So with me is Corey Salzillo with the Sheriff's Association, or State Sheriff's Association.
Thank you, Assemblyman. Please.
Mr. Chair and members, Corey Salzillo here on behalf of the California State Sheriff's Association. We are indeed the sponsors of this bill. As the Assembly member stated, this is simply a bill that would give sheriffs the option. It wouldn't mandate nothing. It would give sheriffs the option to issue a more user-friendly card, if you will, in the context of carrying the CCW. There's nothing in the law that says you should carry it, but common sense dictates that if you are going to be carrying concealed, you should be carrying your concealed weapons permits. As Mr. Linder said, sheriffs have begun issuing plastic-type cards that are easier to carry, that stand up. They don't have to go through the wash. They're not going to disintegrate. They don't have to be reissued. And it aids identification. They'll include a picture. They'll include all of the same information that is required by DOJ right now on the concealed weapons permit. So we think it's just a user-friendly, it's easier to identify, and we think it makes the issuance of CCWs a little more streamlined and easy. And so we're just we're looking for that ability to do that, and requires nothing of sheriffs. So we thank you for your aye vote.
Thank you, Mr. Salzillo. Others in support?
Yes, sir. Roy Griffith speaking on behalf of the California Rifle and Pistol Association and the National Rifle Association. We're in strong support of this bill. For the reasons stated, and speaking as a prior law enforcement officer, having a readily identifiable, durable form of ID as opposed to a piece of paper that I myself had to check folks had come out of their wallet and almost fall apart. So this is a great step forward in both uniformity and putting the hands in the local law enforcement who should know these individuals best for the permits. Thank you. We request your aye vote.
Very good. Appreciate that. Thank you. Anyone else who would like to speak in support of the bill? Let those who are in opposition, in support.
Chair and members, Jonathan Feldman, California Police Chiefs Association, in support.
Thank you, Mr. Feldman. Anyone else in support? We'll allow the opposition come up.
Thanks, Corey.
Mr. Chairman, members of the committee, Craig DeLuz on behalf of the Firearms Policy Coalition. Before I get started, I just wanted to make clear that we're excited we've been working with the member's office as well as the bill sponsor and other constituency organizations in order to try and address some of our concerns. But because we haven't come to total agreement yet, we felt that it was necessary to at least express our concerns on the measure. One of the things that's important, I think, when it comes to a concealed carry permit is when one comes in contact with law enforcement and you have a concealed carry permit, you're obligated by law to notify that officer that you have a concealed carry permit and that you are armed. So the challenge is that as we create IDs that are different, we open the opportunity for confusion, and the last thing that I want, and I think any of us wants in the event that law enforcement encounters an individual who is armed, the last thing we want is confusion, because confusion can create tension. The challenge we have is that the bill as it's currently written does not require uniformity of design. It requires uniformity of information, but not design, meaning it can look any sort of way. We believe that there should be a standard. That way, an officer, whether they're in Southern California or Northern California, an urban county or a rural county, can look at this ID and say, okay, yes, this is a concealed carry permit. And that is important, because as bad as the IDs are right now, at least a law enforcement officer can look at it and say, yes, this is an ID. And that's important because right now, neither in current law or in post-training standards, there really isn't training on how to recognize a CCW or concealed carry permit. So uniformity is important. Requiring that there be a set standard does not constitute a mandate, because sheriffs are not mandated to issue IDs. And in addition, they're not mandated to issue these IDs. as the bill is currently stated, they can also still issue the ID that is issued by the state of California. So it's for these reasons. I'm trying to imagine that individual who's pulled over 2 o'clock in the morning in an area far away from where they live, and an officer, they give the officer their ID, and now the officer is now charged with the challenge of this. He says, he has to say to himself, okay, I don't know if this is real. Do I leave an individual who is armed, who's already notified me that they're armed, sitting in the vehicle while I go and check out the validity of it? We believe that with uniformity, we will remove that. And as I said in the very beginning, we've been working with the member's office, and I believe that we are very, very close to coming to some sort of an agreement that will both modernize the ID, create it, and as well, and protect CCW holders, as well as create the uniformity we need. Thank you.
Madam Chair and members, Sam Paredes representing Gun Owners of California, and we stand here in great agreement to the comments made by my colleague here, and we are very pleased with the author and the sponsors of this bill who have been working very hard to negotiate, work out, compromise, come up with a process that we think will be a good one. This is a very, very important issue. For some people, it might seem like a very trivial thing, but it really, really is a very important issue. Legally authorized and recognizable identification cards that are issued by the government should be considered with great care. And you should be looking at the potentials of the impact of that. We have a position that is in opposition with, unless amended, and we're confident that we are very close to meeting the amendments that are necessary to make sure that this thing is a very, very good benefit to all CCW holders in California. Thank you. And law enforcement. Thank you.
Speakers in opposition to the bill? Seeing and hearing none, I thought the bill was pretty okay the way it was myself, but whatever. Are there questions or comments from members of the committee? Yes, Senator Stone.
Welcome back, Madam Chairwoman. Assemblyman, I think that your bill is well written. I do believe that the opposition does bring some very important points up with respect to uniformity. The state of California has gone to great lengths to make sure that our driver's licenses are made in such a way that they're very difficult to fraudulently make. And I think if I was an officer stopping somebody and looking at something that I was unfamiliar with, the sheriff in another county that gave a CCW, it does create some tension and some public safety issues. As you know, somebody's armed and you want to make sure that that CCW is legitimate. Last thing we want is an illegitimate license, and as the officer's going back to the car, they get shot. I would like to move your bill today with the hopes that you'll continue to work with them so that some type of uniformity can be accomplished, but also prevention of forgery, which I think is very important to me, that it can't be duplicated very easily, so that we don't have people carrying quasi CCWs that aren't in fact real, giving the false impression these people can carry when they really can't carry, and may be very dangerous individuals. So I applaud you for bringing this forward. Obviously, the one that the Attorney General gives is not sufficient to withstand a washing machine.
And easy to counterfeit.
Or jumping in a pool with your wallet. So for those reasons, I'm very happy to move your bill today with the hopes that you'll continue to work with us.
The bill has been moved. Any other questions or comments? Would you like to close?
Certainly, and thank you. I'd like to just address some of the concerns. One thing, it was mentioned, being able to counterfeit. The current identification, it's written on it's printed out on a piece of paper that's actually very easy to, it would be, I would imagine, very easy to counterfeit. These cards that are issued by our sheriff's departments are, they're typically made out of plastic or laminated and provide a little bit more of a difficulty in counterfeiting. So I hope that we would, of course, like to make sure that if there was a piece of identification that was impossible to counterfeit, I'd like to put that out there. So, of course, it's going to be very important to us to do this. I'd also like to mention that the goal goals that we have, even with the opposition, are the same. We would appreciate something that is as uniform as possible and provides as little confusion as possible. So the goal is the same, and we are working together for that. We need to do it in a way that is productive and efficient and doesn't cost the state a ridiculous amount of money, and that's where the challenges come together. But in saying that too, one of the bigger concerns is that police officers aren't able to identify between different types of, different forms of IDs. Well, they are trained to be able to recognize 50 different driver's licenses from 50 different states. Different agencies have different licenses that they also have to be able to verify. So that being said, it's still very important to me that any confusion that might be out there is as minimal as possible when you're doing something as dangerous as conducting a traffic stop. So AB 2510 provides an alternative avenue to ensure proper licensure and identification. This is an optional system. It's optional. And that will release the burden of the cumbersome permits that are currently provided. So respectfully ask for an aye vote.
Thank you. The motion is due pass to appropriations. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson? Anderson, no. Glazer? Aye. Glazer, aye. Leno? Lou? Lou, aye. Monning?
Aye.
Monning, aye. Stone? Stone, aye.
Okay, that bill has enough votes to pass. We'll hold the roll open for the absent members.
Thank you.
Assemblymember Gonzalez has been here very patiently. Item 7.
All right.
Yeah.